was born on June 16, 1915 in Denver, Colorado, the third child of Howard and Nellie Jenkins. He graduated from the University of Denver in 1936 and from the University's College of Law in 1941. Although he was not the first African American to practice law in Colorado, he was the first African American to pass the Colorado bar examination. In 1940 he married Alice Elaine Brown, the daughter of a prominent African American minister. She graduated from the University of Denver in 1937 and was the first African American to teach in the Denver public schools. Howard Jenkins became interested in law when he accompanied his best friend to watch his friend's father, Sam Carey, try court cases. Jenkins practiced law in Denver until 1946, first in private practice, then in the Denver office of Price Administration with Edward E. Pringle and Max Melville, then at the Denver War Production Board with James C. In 1943 Jenkins was appointed regional attorney for the National War Labor Board, and in 1945 its chief regional enforcement officer. For William Willard Wirtz on the National Wage Stabilization Board, and joined the faculty at Howard University School of Law. Supreme Court to desegregate the railroads and the public schools, including the landmark case of Brown v. While special assistant, he was intimately involved in drafting and passing the Landrum-Griffin Labor Reform Act, known as the Employees' Bill of Rights. In 1959, Jenkins was named Director of the Office of Regulations at the Bureau of Labor Management Reports. In 1962, he was named Assistant Commissioner of the Bureau and became the highest-ranking African American attorney in the federal government. In 1963, Jenkins became the first African American to be appointed to the U.S. Jenkins was reappointed by 3 subsequent presidents and served on the NLRB for 20 years. His mission was to help them discover blacks in the industrial workforce, and to get it firmly fixed in our national labor policy that discrimination on the basis of race or sex is an unfair labor practice. He also wrote a dissent, affirmed by the courts, holding that it was illegal sex discrimination for unions to have a waiters' union and a separate waitresses' union.